Hello and welcome to another edition of In Session with Judge Ashley Willcott and Michael Ayala. Thank you so much for being with us. Judge Ashley, great to see you. I hope you had a great weekend.
I did. A happy belated 4th of July to you, and great to see you as well, as always. A lot of things to talk about as we have our freedoms in this United States of America.
Yes, we do indeed. And we have a great show for you guys today. We'll be touching on and getting you caught up on the latest in the Alec Murdaugh case. Again, his defense attorneys now are preparing for that new trial that's set for April of next year. And they're taking a much more aggressive posture in that case, really trying to develop this third-party perpetrator theory that they have for the case and trying to get some DNA tested. We'll tell you all about that. Also, Judge and I picked out a couple of cases from the last term that just finished up of the Supreme Court of the United States. And we picked a couple of cases that we thought were important, but maybe got kind of lost in the shuffle a little bit. So we'll tell you about those. And then, of course, we're going to have our home corner where we talk about issues at home. And I'm actually going to be seeking some advice from Judge Ashley with some issues I got with my wife. So I want you to stick around for that as well. All right, folks, sit back, relax. In Session is in session.
I love that, Michael. That's fabulous.
Judge Ashley, let's begin talking about the Alec Murdaugh case. As I said, most of our viewers will already know that just a few weeks ago, his conviction, his double murder conviction, was overturned. And it was overturned. Actually, let me call up a picture of this woman because I want to ask you something. But anyway, this is Becky
Oh,
Hill.
the
It
lovely
was
Becky.
overturned because this woman, the clerk of the court, had basically denied his right to a fair trial by making all sorts of suggestions. It was really absurd, the type of things she was doing, making suggestions to the jury as she was controlling them throughout the trial. She was trying to promote her book and trying to, at least according to some of the things that were said, but trying to sort of direct the jury to a guilty verdict. And I think we all agreed that this was one of those situations that was very suspect. And we were not surprised when it was ruled that he should get a new trial.
Right, not surprised at all because I have to tell you, you remember when we were covering this and we were sitting together on the desk and watching and hearing some of the things she was rumored to have done. And I was so bothered and said, if any of this is true, it's a problem because nobody related to the court gets to interfere with the Sixth Amendment right that a defendant has to a fair and impartial jury. And she did. That's what the court found. So this one really bothers me. She should have known better, Michael.
Yeah, I would have to agree. And I wanted to ask you, you were a judge, and I'm sure you had a clerk of court. Was Tell me about the relationship between the judge and the clerk of court and what their duties generally are, what she was supposed to be doing as opposed to what she was doing.
Right. So she's first an extension of the court. And remember, court and court staff are usually in close quarters because these are government buildings. So they're not as big as and expansive as maybe a private corporation might be with these huge offices. You're generally in close quarters. And when I would sit in the judge's office, I could hear what my clerk of court was doing. I could hear what my assistant was doing. I could hear what the law clerk was doing because we were in close quarters. So the court clerk is an extension of the court. And really, I think my best description would be they have to do everything to make sure that the court runs the way it's supposed to, that the jury gets where it needs to be, comes into court on time, that all those logistics, which are many and can be tedious, are done for the court as an extension of the court, really at the judge's request. That's how I would describe that relationship. And some judges may argue, well, I'm not that person's boss, right? That there's an administrative arm of the court and they have a boss over the clerk of court, not the judge. But here's what I would suggest to you. Even if HR diagram chart, that's correct, as a judge, I think it's still incumbent on you to make certain that those people involved with a jury, involved with a case in your courtroom are managed to the extent you want them to be to make sure they're doing the right things and they are not doing anything unethical, which I believe Becky Hill was.
Yeah, no question about it. And it was interesting because she seemed to have a decent background. There was no history of this, but this particular instance, the opportunity for money and fame really just seems like it actually got the best of her. And as I said, none of us were really surprised when this came down. I want to take a listen here, Judge, to the response of Murdaugh's attorneys. This particular one is Jim Griffin. He's basically talking here about a civil suit that they've filed against her. And then we'll talk quickly about that. So I want to take a listen to that.
On the lawsuit on behalf of Richard Alexander Murdaugh Sr. versus Rebecca Hill. In this lawsuit, we file it under the federal civil rights statute, 42 United States Code 1983, to redress constitutional deprivation of rights. Those rights were Alex's right to a fair trial, a right that can be tried before an untampered, untainted jury. With the South Carolina Supreme Court's ruling, it has been adjudged as a matter of state law that she deprived Alec of his constitutional rights, deprived him of a right to a fair trial, and as a result, we've got to do it all over again, which nobody wants to do. The damages that we
All right, Judge. So that was Jim Griffin again. He is the attorney for Alec Murdaugh. And, you know, he points out the fact that he's filing this claim. Now, it's a civil claim. And you see 1983, Section 1983, very powerful weapon used by many civil rights attorneys to go against people who are working for the government, acting under the color of state authority, and then violating someone's rights. And we've seen some very, very large awards. What do you make of this civil suit under these circumstances? She's actually filed to get it dismissed. This is a textbook example, and I think she's probably in a very bad spot.
That's what I was going to say, Michael. I'm not at all surprised that it wasn't dismissed, because I think it's a valid 1983 claim, because he's right. The Supreme Court's already made a ruling as to what was wrong with what she did. And I think now you have that basis to support the 1983 claim against her. Now, I am going to ask you this, because one of the things that stood out to me was when he said, and now Alec Murdaugh has to go through it all again. The fees and costs, specifically attorney's fees connected with that, have got to be astronomical. So you're a defense attorney. You served as a defense attorney. If you had to guess, what kind of number would you put on the amount that Alec Murdaugh's going to be out of pocket to pay for the fees caused by the actions of Becky Hill, really, at the end of the day?
All right, let me tell you this. It's not only the money that they're going to spend, I'll talk about that in a second, but also the money that it costs the state of South Carolina. I mean, the ridiculous amounts that it costs to redo this trial. This is a long trial, get the people in, you know all that. But as far as the money, they actually did, Dick Harpootlian and Jim Griffin did an interview about this. And here's what they said. They didn't talk about the actual fee that they paid, they were paid for their own services. I would imagine a trial like this, that's over $1 million for lawyers like this. These are big time attorneys. But what they did say was just for trial preparation, experts, testing, all those things, that alone was $600,000, Judge. They said right now, Alec Murdaugh has no money. They said, look, as a defense attorney, you represent someone, you have a job to do, and this is part of our job. We want to see this thing through to the end. If he doesn't have any money, he doesn't have any money. We are obligated to see this thing through to the end. That's how they see it. So that's kind of where they are with this whole money thing.
Yeah, and that's why I think they may be, if they're successful in a 1983 claim, it could benefit everybody financially. Let me say this, because I want to remind everyone that this is only for the murder trial. So that Becky Hill Supreme Court decision did not at all affect his current convictions for the financial fraud crimes. And we know, if we think back to that, Michael, $10 million is what Alec Murdaugh admitted to stealing, right? And so he has a federal sentence for federal financial crimes. He also has a state sentence for the state financial crimes. He was sentenced to 40 years in federal prison, then to be served at the same time 27 years in state prison. My point is, in spite of this going back to trial, it's not like he's going to walk out of jail tomorrow.
No, he won't walk out of jail. It's interesting you brought up the financial crimes, because the financial crimes were a major part of the prosecution's case the first go around. But what we know from the appeals decision that overturned his conviction is they gave some directions to the court that will be trying this case a second time. It'll be a different judge this go around. Judge McCaslin is going to be trying this case. And what their instructions were, they said, hey, you need to streamline those financial crimes and the evidence allowed in about the financial crimes. We all said during the trial, we felt it was overkill. We felt they let too much in. And a number of our guests who had been prosecutors talked about the fact that they like to err on the side of less so that there's not an issue on appeal. Now, that wasn't the reason they overturned this case, but they did give them the admonition, hey, cut back a little bit on those financial crimes, even though it is the linchpin of their case because it provided the motive.
Right. It provided the motive. It went on and on. I remember watching it thinking, oh my gosh, this is not a trial about the financial crimes. But you know what I wonder, and I don't know if this can be forced, but I wonder if theoretically the evidence of the conviction in federal court, which you can get a court certified copy, as well as the conviction in state court, another certified copy of the financial crimes, would that be enough? Yeah, that's the motive. I mean, that's the best evidence of it, or is the state going to say no, we need the jury to hear the emotional aspect of it to get them to buy into our narrative?
You're absolutely right. They could absolutely stipulate to those convictions, but the prosecution is not going to want to do that, Judge, for the exact reasons that you mentioned. Yeah. They need this jury to hear the machinations that this guy was going through, because it has to support the idea that it would have resulted in him ultimately killing his wife and son. And I remember hearing the things that he was doing. He was robbing Peter to pay Paul, covering up here, lying there. All those things created a sense of desperation on behalf of Alec Murdaugh that then you could believe he would have taken the actions, the extreme, the ultra extreme actions of killing his own wife and son. So I think the prosecutor is going to want to get that type of information once again in front of the jury.
I just have to push back and ask you. I found him very pathetic, a pathetic liar, when he was going through all that testimony for the state. Is there any opportunity that the defense can use that as pathetic person to get the attention of a juror to feel sympathetic for Alec Murdaugh, not based on the first conviction? But I wonder that if you put too much out there as the prosecution, is he so pathetic that people feel for him?
Well, I'm looking at a picture of him now, and to me, that's a scary dude. I mean, look at the eyes of this guy, right? I mean, there's something wrong with this guy. You can see it. He's a scary dude. I never met him in person, obviously. He's a big man, but certainly a scary dude. And I would say this, Judge, he took the stand in his murder trial, and that didn't work. And we saw him up there crying. He tried to evoke tears. He tried to evoke emotion. And it was, I mean, I don't want to say we laughed at it, but we laughed at it, right?
Yeah.
Because at the end of the day, it just wasn't working on any level.
Yeah. Yeah. To me, he's the kind of person who is charismatic his entire life, and it's worked. People, because of his power and his money, have done what he's wanted, have done what he said, have done what he suggested. So I think he thought he could get up there, testify, and of course the jury would do that for him. He's in a different position, no power, no money, and the jury didn't buy it.
Excellent, Judge. Excellent. I absolutely agree. Round of applause. He took the stand, and I think we talked about this. Come from a family that's basically run the legal community for your whole life and all the way back a couple of generations, and you think you can get away with anything. I think that kind of led him into this whole situation to begin with, and I thought he could get away with it. I thought all of that was coming across while he was on the stand. It didn't work at all for him. Let's turn now to this new case coming up in April of 2027. The main issue that I wanted to bring up regarding this retrial is we know in the first trial there was this issue out there that there was some DNA found, I don't want to say under, but found on some fingernail clippings of Maggie, the wife. Now, in the first trial, the way the defense used that information, they hadn't really developed anything beyond that because it was unidentifiable. It didn't match Alec and it didn't match the son either. So the way they used it was, look, there was this unknown DNA out there, and they used to say that SLED, the folks who investigated this case, didn't do a real thorough investigation. They used it to say, look, there was this third option out there. You trained your eyes on Alec Murdaugh, and you didn't even go down that road, and that could have been something significant. That's the way they dealt with it in the first trial. This trial, they're being much more aggressive. They're saying, we want to get that DNA tested. We want to use a special lab that specializes in genetic genealogy and all this business because we believe that this could be the real killer. Whatever DNA was on that fingernail could be the real killer. What do you make of it?
Michael, you always ask the greatest questions in talking about the defense wanting to do that DNA testing on the fingernail clippings. Two things the prosecution is saying. First, the prosecution is saying it's just touch DNA. She'd even had her nails done, so it wouldn't be a good indicator of what was under the nails. It could be anybody. So they say, number one, shouldn't be allowed by the defense. But number two, they are going to raise an issue that the judge is going to have to do a balancing act because the prosecution is saying the problem is there are not a lot of nail clippings. And if the defense takes them and has their expert test for DNA, there won't be enough left for the prosecution to also have an expert test that DNA to validate whatever the defense learns. And they're saying, Judge, that's not fair, that's not okay. And the actual test that the judge has to consider is materiality versus destructive testing. That's the standard. The judge has to weigh both and decide what she's going to rule.
Yeah, and the prosecution's arguing, look, this has already been litigated. They're saying that this is, just trace type DNA that can be transferred under so many different circumstances that it's really not relevant to the case. They also say, Judge, look, there were no defensive wounds. So if you're going to try to tell me that the perpetrator who did this was someone that she had contact with prior to this killing, where's the defensive wounds? How did this all come about? So they don't think the evidentiary value is there in that DNA. So that's what they're arguing. And like you said, the judge has to make a decision with that weighing test. The other thing that's included in that test is, she has to sort of err on the side of making sure that this is a fair trial for the defendant, that they have a full opportunity to present a defense. So she has to consider that as well. If she denies it, it could be sent back. But if she has good reason to say, look, there's just not enough DNA here. It's just trace DNA. I couldn't possibly do it and have it be tested a second time. So it just didn't make sense. They litigated it the first time. What do you think the judge might do, Judge?
I think in that case that she may not allow the defense to do it. For the reason you said, it's not just one of those things. It's trace DNA, maybe, if, and it would use all of the material and it couldn't then be tested also by the prosecution. Now, there's one other option. So I think based on that, I don't think she's likely to allow it. But there's one other option. She could say, all right, we'll get it tested once. And I'm going to pick the provider. And if you all want to go get it tested, that's great. But then the defense isn't picking it and the state's not picking it. You don't get to validate it, but you haven't picked who did it in the first place. So that's a creative option. I don't know that she'll do it, but as a judge, I might consider that.
That's actually a wonderful idea. I didn't even think of that. The lab that I think the defense wants to use is a very expensive lab. It's based apparently in Texas. And again, as I said, they did forensic genetic genealogy stuff. So apparently what the judge told them, and I wonder if this is any clue as to what she might do. She said in the last hearing, she said two things. One, she says, I'm going to let you pay for it should she ultimately decide to let it happen, which it sounds to me like that means she might. But she also strictly warned that it cannot delay. Remember we talked about this earlier, the April 5th starting date? She said it cannot delay that. So it sounds to me, Judge, maybe, and you let me know what you think, that she might be leaning in the direction of letting them test it.
It does sound like that, but I think she is really going to create an issue if she decides to let them test it, but truly there would be nothing left for the state to test to validate those outcomes. So I think that's a little bit of a problem.
I think the bigger problem here as we wrap this up is that even if they do get it tested, I don't know if they'll be able to sort of trace it to somebody, if this lab will be able to figure it out. But I still think the defense is going to have a tough time based on all the evidence that I saw in that first trial, suggesting that perhaps someone else did this. There's this theory out there that's been developed, and it's really one of those internet theories that somehow the death of Stephen Smith is somehow connected to the death of Maggie and her son, and that maybe that the same perpetrators were involved. And that was because initially the idea came out from SLED themselves. They said, look, we are going to open up that case for Stephen Smith based on stuff that we found in our investigation into this case, and meaning the Alec Murdaugh double murder case. So a lot of people started speculating, would that DNA have anything to do with that? I still say, even with all that, and I'm sure the judge will keep tight reins on what can be brought in, this defense is going to have a hard time suggesting that someone else other than Alec Murdaugh committed this crime.
I don't necessarily disagree, but Michael, the other thing, and again, this was internet public opinion, a lot of people weighed in and said, no, there had to have been more than one person, that it was unreasonable, the time frame and where Alec would have been and what he would have done to believe it was just him. And so I do think at least public opinion says, hey, we think there was another person. So get this tested, see what it shows, and go from there.
Yeah, I mean, all we really want out of this thing is justice at the end of the day, and I still don't think that information. I agree with you. I thought some of the forensics in the case suggested that there might have been someone else involved. Still doesn't mean he's not guilty. Still doesn't mean that he's going to walk away from this murder charge at all. All right. Judge, we'll stop it there, and we will move on.
Yes. I love that sound. We are talking Supreme Court cases now. And you and I, here's what's interesting. You and I, when we talked to prepare for this show, both of us said we want to do a Supreme Court case, but each of us had a different one in mind and a different case that kind of spoke to us. So I'd love to bring up the case that spoke to me because it's been an issue amongst sporting events and different states and legislation about transgender athletes and whether or not it's constitutional for them to be allowed or required to be allowed to participate in women and girls sports. And really I said that backwards because the constitutional issue is, can a state legislate and say that transgender are not allowed to participate in the girls and women's sports? And so the Supreme Court took it up and they issued a ruling, and they decided, and this is what's really interesting to me, I think they sidestepped the transgender issue altogether. And here's how they did that. They said under Title IX and the Equal Protection Clause, these girl sports can remain girl sports. And no, transgender boys, they don't need to be allowed to play in those. So therefore, the state legislation is not problematic. It's not unconstitutional. But a lot of people aren't happy with that because they think, including one of the dissents, went right around that whole transgender participation issue.
Yeah, it's interesting because they decided that, as far as the way I read it, transgender is not a classification that requires strict scrutiny or a strict look by this court, right? They basically said this is about male and female participation. So there's intermediate scrutiny. And so what we're going to do is we're going to ask, is there a substantial state interest and is there a legitimate reason that they need to protect that interest and they can make this law, right? So at the end of the day, they decided that the safety and the competitiveness of events involving same-sex kids essentially is a compelling enough reason or is a substantial enough reason for them to say, look, I'm not going to allow transgender folks to compete in sports not of their original birth sex. And I think on one level, I agree with it. I was never a big fan of transgender athletes, but I also understood that if the Constitution is found to have protected transgender folks, then they have every right to do that. Well, this court said no, the Constitution does not protect transgender. They are not a protected class, like, let's say, race, sex, or sexual orientation. So I think that was the big story coming out of this case, that transgender did not get its own classification.
But I think I would caution, this was specifically as to athletics. And I'm not convinced the Supreme Court may not go another direction if it becomes about marriage or one of the other issues. We'll have to wait and see. But also, we talk a lot about with the Constitution. Did the framers of the Constitution ever anticipate that there would be such a thing as transgenders or gay marriage being an issue to be addressed by the current day society? Certainly they knew things would change in the future, but I don't think we could believe that they anticipated what those changes would be. And so the Supreme Court has to grapple with unique first impression issues, and this is one of them. I have to tell you, I know we're going to talk about family later, but a couple of years ago we went to a volleyball tournament, and at that volleyball tournament there was a player who was so head and shoulders above all of the rest, everybody else in that gym at their level of competition. No one could return the serve. It was a college level serve for ninth graders. And all of the parents ended up watching this game because it was just phenomenal, the athleticism and how much better this player was. Well, after the tournament, I didn't know it was transgender, and so it was a biological male. And the level of playing, Michael, was it just was unreasonable in terms of nobody else in that gym that was not transgender, that was biologically female, could compete.
Yeah, I think that's the problem, right? At the end of the day, I mean, we saw the swimmer, I think it was at University of Pennsylvania, started setting records. And, I feel for the parents of women. I don't have daughters, I know you do, who compete, as you just mentioned. And I think it would bother me to no end to know that they were in a position where they were competing with someone who perhaps had an advantage on some level. One of the interesting things that the court talked about was, this whole idea of figuring out what level of hormone therapy they're at or whatever was just too much to ask. And again, these are all things that I've felt as this case or this story has progressed over the years. I felt, do we have to constantly test them? What level are they at? What point are they in terms of their making the transition and things of that nature? It just becomes so complicated. There's actually an Olympic runner as well who's done well, who's transgender, who has their hormones tested because the Olympics does test and they sort of fit within the parameters prescribed by the United States Olympic Committee. So, it just becomes too much when you talk about high school sports or collegiate sports. I just felt like it was a bit too much. The opposite side, though, Judge, and this is what I want to get you to comment on, is that now we have these athletes who are making a transition, who are transgender, who have nowhere to go. I feel for them. I absolutely do. So what do we do with them?
And that's what's so hard about this, and where you have the human compassion for these kids, older individuals, even adults, because where do they land? And so arguably, I guess you can look at the opposite, which is, well, if they're biologically male, then they can play in the male sports. But that's a whole nother host of issues because they're transgender. They're not going to look necessarily like the rest of the boys on that sport. So mark my words, I think my prediction is within the next 2 calendar years, we are going to see another transgender case get to the Supreme Court level, maybe not about athletics, but about a right.
Yeah, and do you think it might have legs or an opportunity? I mean, I think the court was pretty clear that they're not willing, at least this court, and this court's going to be around for quite a while, is not willing to create a separate category that's protected in the same way as other protected categories for transgender.
I think you just hit the nail on the head. If it's the exact same court, I do not think it would be a different decision because, like it or not, you and I could talk about each justice and predict where they're going to land on certain issues because we know they were questioned before they were ever confirmed. We know where they stand on a lot of issues. So, same court, not likely to be a different decision, in my opinion.
All right, Judge, I want to talk about a case that involves questions about privacy and our phones. Again, this is one that might have fallen under the radar for a couple of reasons, but I think it's important nonetheless because the question is, are our phones an invitation to violate our privacy? It was the case of Chartry versus the United States. It involved geofencing by law enforcement. Now, quickly, let me explain what geofencing is through describing what this case was about. There was a robbery that happened in Richmond, Virginia. The police had no leads for this robbery. So what did they do? They used something called geofencing, and some of our viewers may have seen it, some of the cases we've covered, where they send out this blanket dragnet. They get information from places like Google or Uber or different places as to the location data on people's phones. So they said, we got no leads in this case. So they took the address of where the robbery took place and got the information from Google of all the phones 30 minutes before, 30 minutes after the robbery that were in a 2-mile radius of this place that was robbed. I believe it was a bank. And so through that information that they got from Google, Google has to turn it over because the law right now before this case was that, yes, those are business records and you can absolutely turn it over. So your information, my information, anybody's watching information is fair game under these circumstances. Well, they narrowed all that information down and were able to catch the robber. So it's actually an effective law enforcement tool. But this guy sued, and he said that his Fourth Amendment right to be free from unreasonable search and seizure was violated. The case got different opinions, making its way through the courts, ended up in the Supreme Court. And ultimately, the court decided for the good guys, and I call us the good guys, people. Because I've always been concerned about with this surveillance state and with all the things, the information we give away on our phones, how much of our privacy were we giving away? Well, Judge Elena Kagan, she wrote for the majority, and I just want to pull out the most important quote from her decision, writing for the majority. She says, an individual has a reasonable expectation of privacy in records about his cell phone's location, and police intrude on that constitutionally protected interest when they demand the information, even though only for a limited time from a third-party tech company. Judge, that is huge. And so now our phones, they're starting to develop this line of law that says we have an expectation of privacy with our phones. Hallelujah.
Yeah, hallelujah. When you told me about the facts of the case, I said before you could finish, I haven't read the case. Please tell me they allowed us our privacy. And they did. I think it's absolutely the right decision. And I think the reality, though, is it's still kind of a warning message to all of us to remember how much they can learn about us, even correctly and constitutionally. One thing that stood out to me in this case is Justice Alito wrote a dissent, and it wasn't him saying there's no right to privacy, it should always be accessible. That's not his dissent, but rather he felt like they should either have dismissed that lower case or, in the alternative, relied on a good faith exception. So you may ask, what's a good faith exception? Well, what he said was that this is when evidence should be admitted if the officers who collected that evidence, in this case, all that Google history, believed that they were acting in good faith, even if it was prohibited under the Fourth Amendment of getting that information. If they believed they were acting in good faith, that there's a good faith exception. So that was the nature of his dissent. And I guess I read it, Michael, and I'd love to know your thoughts, because I thought he's still saying the right thing, which is there's an expectation of privacy.
Yeah, yes, I have a lot of thoughts about that. So number one, the ultimate decision by this court was that people do, in fact, have a reasonable expectation of privacy on their phones. So what they ultimately did was send the case back to the lower court to determine if, in fact, they could use that information, if the warrant gotten for that case was reasonable. And to your point, I think that lower court is going to find that it was reasonable because of the good faith exception. Because the law, when they made that warrant that asked for that information 30 minutes before, 30 minutes after, 2-mile radius, while today that would not be something that would be allowed, back then it was, because the law of the land was that information was available to them under the law. So that will pass the good faith exception. It will be allowed, and he will continue with his sentence. He actually pleaded guilty, but preserved the right to appeal. So that's why it ended up in court. But what I want to say about that is the Judge Alito is absolutely right. This is a case that the court should have said, this issue is now moot, because Google no longer keeps that information. Since that case was filed, they stopped keeping that information, and you now, as an individual, are the only one keeping that information on your phone. So the issue was actually moot, but I believe that this court wanted to make this decision. They want to begin dealing with this issue. That's the only reason I can think of that the court would go ahead and make a decision on a case that they didn't have to. Because as you know, the Supreme Court doesn't like to make decisions on cases that are not what they call ripe, that you don't need to make a decision on. They want things that are expedient, that are happening then and there.
So I have two thoughts. The first is, Google has phenomenal in-house attorneys as well as firms that they utilize, brilliant attorneys who I would have said this was the smartest thing you can do. Remove yourself from the equation. Stop keeping track of that data. Let the individuals do it, and let subpoenas and law enforcement and prosecutors go after the individuals. Leave us out of it. And I do wonder if the Supreme Court wanted to make this statement so that other companies that have the ability to track all of our phone information might say, wait a minute, let's also remove ourselves and not track it, giving us even a greater right of privacy or benefit of privacy on our phones. I don't know.
Yeah, no doubt. And there are other companies, even though Google stopped doing it. Companies like Uber, for instance, they keep all that geo-tracking information. So they've been put on notice for that as well. So this case essentially stands for the proposition that if you want information, so for instance, in this case, they couldn't get all that information now from all those people who were in the area that they used to whittle down to find this robber.
Right.
Because they would then have to get a warrant that was specific enough, and they would have to have enough probable cause to get the information off of all those individuals' phones. Not sure they could reach that under certain circumstances. Perhaps they could, but in this case, I'm not sure that they would be able to. So, Judge, of course, the law enforcement folks, the law and order folks say, you struck one for the bad guys here. You're helping the bad guys in this situation. What would you say to them that they've weakened the ability of law enforcement with this law to solve crimes?
Because probable cause has always been something that they've needed in order to obtain a search warrant, a warrant, come to court. You've got to show me probable cause. That is still standing true. All this does is say you still have to give me probable cause. It's not enough to say we want to look at all the people who entered this bank for a 2-hour amount of time in this radius, and then we'll narrow down those people, because it's a fishing expedition from my perspective, right? So yes, it's a great tool for solving crimes, but not at the risk of divulging private information. And the people could be doctors, they could be lawyers, they could have confidentiality requirements, and all of a sudden all that information's being provided. That's dangerous. That's a slippery slope. I think it's the right decision. But Michael, also, and I'm a little surprised they didn't comment on this, as I read it, the facts of the case, the number of people identified during the specific time frame and the specific radius boiled down to only 19 people. And the law enforcement was then able to go through 19 people. It's not like it was 1,900 people or 190 people. It was only 19 people. So did that really violate privacy to the extent it sounds like it does? That question wasn't at all addressed, but it's a difference to me to say there were only 19 people identified that we're now going to consider versus a bigger number. Still think it's
I
right.
disagree.
You do? Tell me why.
I disagree with that. I think whether it's 19 or 1900, those people's rights were being violated, right? So I don't care about the number. That's how I kind of look at it. Here's what Justice Kagan had to say about that very issue. She said, even that small amount, she emphasized, can provide significant information about someone that they might prefer to keep private, to your point, including visits to the psychiatrist, visits to the plastic surgeon, the abortion clinic, the AIDS treatment center, the strip club, the criminal defense attorney, or a by-the-hour motel. She's saying all these things we have a right for people not to have access to, for people to know, to be questioned about. And I agree with that 100%. And so I think they absolutely got it right here when we start talking about the ability to have a certain amount of privacy. It's interesting, Neil Gorsuch, he wrote a concurring opinion where he took it to the next level. This is, again, not the law of the land because it's not the majority decision, but he said he believes that this information rises to the level of a property right, which takes it even to another level. So it'll be interesting to see as this evolves, if these rights that we have with our phones rise to the level of property rights at some point? Because again, as this opportunity to continue to surveil us and all the ways that they can keep track of us, we have to remember there's a social contract, Judge. We agree to give away certain rights for our safety, right? We have to. But the question is, where is that line?
Sure.
And I'm always reminded of, the car industry. They could make cars, Judge, that would make it so that no one ever got hurt in a car accident. But the cost of those cars would be prohibitive so that no one could have a car.
Right.
So you have to have this cost benefit analysis. How far are we willing to go for our safety? How much of our rights are we willing to give up? And I think this is one of those type of topics that raises that question, to your point.
But I have to take issue with one thing you said. Now I know, Michael, we can't legislate morality. However, when you said, and they've had in the opinion, an hour rental, hour by hour at a motel or a strip club, my immediate thought is, fine, I want to know if people are going there in my life. Because if they're going there, I should know about it. So I'm fine with that right of privacy being violated. And that's not really true. But I think the point is we can all get emotional about this because we think of what it could provide as information. But we've got to keep in mind that slippery slope. And we don't want our rights violated. And if those 19 people's rights could be violated, so could ours, to your point.
All right. So here at home, my wife and I had a little bit of an issue. And it revolved around a gift I had given her about 18 months ago, a little bit more than that. So she was, getting into her fitness thing, Pilates and yoga and whatnot. So me being the dutiful husband, I got her a yoga mat and a weighted vest, one of those small ones that goes over your shoulders. So when you walk and stuff, it helps you lose a little extra weight, makes you work harder. Now, Judge, for the last 18 or so months, it's been sitting in the very same corner of her office as when the first day I gave it to her. Okay? Now, I got no problem with that, whatever. But I said, look, I need a mat. I'm working out at home a little bit more now. I need a mat. So I started using the mat. And then I said, well, I'd love to use this weighted vest because, because it could help me doing push-ups, it's whatever. I'm not a big walker, but when I do walk, I could use it as well. So I started using it and she noticed it and got very upset with me. Very upset, like much more upset than I would have expected. So I just want to check with you. Am I completely wrong here? Again, it wasn't to show her up. It wasn't to, make a point. I honestly just was like, I need one of these. Here's one. She hasn't used it. I'm going to use it. And it wasn't going to stop her from using it or whatever. But boy, she got upset.
So listen, I get why. I get why. So, you and I at Court TV had our offices next to each other. Full glass windows with a curtain, so I could walk out of my office, turn left into your office, and you would walk by my office every day. So I have to relate this to Michael walks by my office and sees a half of a sandwich or a jar of candy, and he says, "Oh, I think I'll have that," and he takes
No,
it.
you
and
can't
goes.
get those back, Judge. Once I eat the sandwich, it's gone.
It's gone, but I would say this. I think spouses are so sensitive. We do have great ones, but they're sensitive. I think you can only use a gift you've given them if you get their permission first. So when you were thinking it's been 18 months, did you say that out loud to her, or that's what you thought when you took it?
No, so I didn't make any big deal of it. I just started using it. And when she confronted me about it, that was the reason I said, honey, I need it. This is not just something I'm trying to make a point. No, I was actually needed it. And she knows I use it. I work out regularly. So my point was, well, it's been sitting in your office for 18 months. So I just thought I'd use it rather than buy a new one. That was kind of
Michael, don't go there. Don't go there. No, because you know what she's thinking?
Now that you made me say it, I kind of get it.
See? Because she's thinking, go buy your own damn mat and your own damn vest. You can afford it, mister. Leave my stuff alone. That's what she's thinking, because that's, if I get a gift from my husband, that's mine. You don't get to use it. You don't get to do anything with it unless you ask me.
Yeah, and I do have a little bit of a. I probably have done that before, actually. So
You know
maybe it
what's
wasn't the
funny? When
first
you and I
time.
have talked
I've done
about
it
our
in a while, but it
when
wasn't my
we
first
talk
time.
about our spouses and different issues, I feel like
Yeah,
half the time as we were talking, we'd be like, well, this kind of had come up before, right? So then you know you're
yeah,
sunk.
exactly. And the word Indian giver was thrown around a couple of times, because I think I've done that. So she was
Yes.
probably in the right. And so, and the worst part of it. So once it's done because I said,
Yeah.
okay, honey, I try to say here, I'll give it back. She don't want it now.
No,
She don't
of
want it.
course not.
She,
You
you
need to
know,
go buy her a better one of each. That's what you got to do now. Or a Peloton or
not only
something.
another one, Judge, I got to buy her a better one.
Yeah.
So whatever I bought, I've got to buy the next level up, right? The better one is what I
Hundred
got to get her. So,
percent. And even if it weren't true, if it were me with my husband, I'd be like, well, it smells now, or it looks like you, or it feels like you. I don't want it.
right.
Like, I'm not using it now. Even if I was making that up, I'd be like, no, I'm not using it now. Nope.
I don't want nothing to do with it. I don't even want to touch it. All right, Judge, send us home. We're pretty much done today. Thank you for that advice. And as usual, you're probably right. And I don't know, I'll figure out something to make it all
You
better.
will. You will. And she'll get over it too. It's as somebody told me once, we always love our spouses. We don't always have to like them. But if we don't like them, we get over it, right? Because we still love them. Listen, if you like this show, please support us. Like, subscribe, join our Substack. You can be a paid subscriber. And Michael, we've talked about we're going to do some additional things for our paid subscribers and let them ask questions and have dialogues and conversations with us. But we just appreciate everyone listening, supporting, commenting. We want to know what you think. We discuss these legal issues because it affects all of us and all of our rights. So jump in and tell us your thoughts.
Yeah, absolutely. And again, folks, we're just sort of getting our feet under us as far as this is concerned. Wanted to get a few episodes out there before we start having those private chats and everything. But those are coming very, very soon. So make sure you like and subscribe on all of the platforms we're on. I know, Judge, you're on YouTube.
Yep.
I know Substack,
Insta.
you're on Substack as well. So please do that to help us along because that really does, in fact, help us. All right, Judge, I'm going to end the proceedings today.
Yes. More.
All right. Court is adjourned. Folks, thank you again. Have a great one.